NAMI Yavapai and the Northern Arizona Peer and Family Coalition present Mental Health Monday. Planning for the future. What happens when a caregiver passes away? Our presenter today is Caleb Lynn with Taylor and Lynn PLLC in Phoenix, Arizona.
Okay, so good morning again. And on behalf of the Northern Arizona Peer and Family Coalition and NAMI Yavapai, I extend a warm welcome to our Zoom audience and our much anticipated speaker for today's Mental Health Monday program. My name is Rose Berner, and I am a member of NAMI Yavapai. We are very excited to introduce our speaker today, Mr. Caleb Lynn, who will discuss special needs trusts, able accounts, powers of attorney, letters of intent, how to protect government assistance, and more. These are topics that are very important for all of us to have information on. So, Caleb, thank you for being our speaker today, and I will now provide you Caleb's excellent qualifications. Caleb is an estate planning, elder law, and special needs attorney. The experiences of raising a special needs daughter and caring for a mother with dementia issues inspire Caleb to assist individuals and families in need. Using his knowledge, empathy, and creative solutions, Caleb enjoys guiding his clients through the complex issues they face in the worlds of estate planning, elder law, and special needs planning. So Caleb is on the board of directors for the National Academy of Elder Law Attorneys, also serving as a member of their journal editorial board. He also serves on the State Bar of Arizona's Council for Persons with Disabilities in the legal profession. So in addition, through peer nominations and reviews, Caleb was selected to Arizona's finest lawyers and presented with an AV preeminent rating by Martindale-Hubbell for excellence in legal ability and ethics. Caleb has also been selected as a super lawyer by Super Lawyers magazine each year since 2019, and a business leader in the field of elder law by AZ Business Leaders magazine each. Oh, I think I said that already. He's since that 2019. See, he's been also a business leader in the field of elder law. So Caleb is also an adjunct professor of law at Western New England University College of Law, and he was asked to design and teach a law school course in special needs trust administration. So that's very impressive resume. So now I'll turn it over to Caleb, who will start his presentation. Thank you, Caleb.
Rose, thank you very much, and thank you all for having me today. And sorry, you had to sit through that. It's always cringy hearing someone read the biography stuff, but I guess it's helpful to have a little bit of background and understanding on who I am and where I've come from. And I do have a special needs daughter, and coincidentally had a early morning psychiatrist appointment with her this morning. So a lot of the world that you guys are living in, and the folks that you're caring for yourselves, I'm right there in the trenches with you due to my sort of personal experiences. So Candy gave me quite a long list of things to touch on today, and so I tried to hit on a lot of those. So we're going to go through all of that plus a little more. So it's going to be really a lot of information. That's why I think it's good if you have questions to just, there's a chat box, or I don't get the way the screen's set up right now, and with the slides I'll put up in a second, I don't think I'll see everybody's hand if you raise it, but that might work. But if it doesn't, go ahead and throw something into the chat, because I just don't want your question to get lost or kind of caught in the mix as we go through a lot of the information. And there may be things that I get to that maybe don't hit on some of the things that you were thinking about or talking about. So there's always room for questions. I think we'll have a few minutes at the end as well. And again, I just want to kind of overlay a little bit of a warning or a caveat on all of this, that there's just a lot. I feel like a broken record, but there's a lot of info here. So it can be confusing. The time that we have today is just a very cursory introduction, just to sort of plant seeds in your heads. So there's always resources. I can point you to resources. I can make myself available to answer questions offline later. I just want to throw that out there so that nobody's feeling frazzled or overwhelmed as we move through the information today. Okay, I'm going to go ahead and share my screen and get the slideshow going. Everybody see that okay?
Yes, we can.
Okay, so kind of some of the broad topics that I wanted to talk about today were estate planning, guardianships, special needs trusts, able accounts, public benefits, go over some questions, and obviously, like we talked about, please don't feel like you have to wait till the end to go through any of the questions. We'll try to address those as we go. So starting basic with estate planning, and the trouble I had is I usually give an hour and a half talk on just estate planning, and then we could make special needs planning, I teach a whole law school course on just administering special needs trusts. So we could, any topics that we talk about today could be extended. So we're really just touching the surface of a lot of these. So I feel while I'm kind of torn, and that I feel really super privileged to be with you today and to be able to kind of plant some of these seeds and deliver some of this information. I also feel equally guilty that we're not digging in on as deep on a lot of these things as I think they deserve. So that's kind of the crucible I'm navigating as we go through this information. But hopefully there'll be certainly some takeaways here, and things that you can, if things are ruminate with you, you can again, we'll deliver the resources to you or point you in the right direction to dig deeper as needed. So starting really high level, talking about estate planning. Estate planning is kind of a really ambiguous term, and in a way it's kind of overwhelming because people, first of all, you don't know what it is. If you talk about appliances, which it's a really weird analogy, but you know exactly what things make up the category of appliances. Estate planning is a lot more vague and ambiguous, and we don't always know what the definition of that even is. And it seems sort of overwhelming too, because that term estate to a lot of us, we think of like somebody who's wealthy or has this, a ton of different, properties all throughout the United States. And that's not the case. Your estate is really what you own. And we still get the question from people that's, hey, how much money do I have to do estate planning? Which is a fair question, but also irrelevant, because you don't have to have any sort of minimum amount of money or category of assets to do estate planning. If you're living and you own stuff, then you're a candidate for estate planning. And so when we talk about estate planning, there's generally some concepts that proliferate or are present in every estate plan. We kind of wanted to cover all of your bases, not just while you're living, but also while you're when you pass away. And Bill and Pam, so just to clarify, they asked that the slide says powers of attorney. So yes, powers of attorney is a type of estate planning device or document. So the next few slides, we're going to talk about different aspects of estate planning. And so typically what those are powers of attorney. We'll talk about those in a second. Last will and testament, and or revocable living trust, and potentially some other additional healthcare documents, which could be a living will, which is a type of advanced healthcare directive, and a HIPAA authorization for your medical power of attorney. So those are kind of the core concepts or what constitutes an estate plan for most people. Now, obviously, there's all kinds of different things they can be added on to that. one of which is a special needs trust. So we're going to get specifically into special needs trust later today. But if that's relevant to you or someone in your family, then that is part of the estate plan on top of those other components that we're going to talk about. So kind of starting at a basic level, powers of attorney. So there's three kinds. There's general or financial, there's healthcare, and there's a mental health care power of attorney. Now, for those of you who haven't been in Arizona very long, or have, just moved here, or haven't even looked, you've been here a while maybe, but you haven't looked into estate planning. Arizona is one of just a few states. This trend is changing, so this is temporary, but for now is one of a few that has a mental health care power of attorney. So it was from a separate statute that created that. So we have people all the time who move here. I was just talking to a gentleman last week who moved here from Colorado and has dementia. And in Arizona, a mental health care power of attorney, the clinicians and the providers will often require a mental health care power of attorney for not just traditional mental health diagnoses and diseases, but also neurocognitive decline or neurocognitive disorders like dementia or Alzheimer's. So it's very important that if that's a diagnosis somebody has or it's in your family, it makes sense. If we're helping someone at our office with estate planning and we're doing powers of attorney for them, we're going to do all three of these. You should have all three. Now, the financial power of attorney, that is a document or a piece of the plan where you're delegating the ability to help you with financial decisions, financial affairs, to someone or someone's who you choose. So basically, your financial power of attorney can be set up two ways. One, that it's active immediately, meaning whoever you're delegating to can help you right away. Or it's what we call springing, meaning it doesn't spring into action or into place until you've been deemed, or the principal of that power of attorney, whoever's creating it, has been deemed incapacitated. So if you set it up that way, the person you've nominated to help you with decisions when you are incapacitated, or persons, it could be one person or two, and you can have a hierarchy. You can have, like, let's say, you can have your brother, and then after your brother either can't serve or doesn't want to serve, then you could put your sister in there, or anybody. It doesn't have to be a relative, even it could be friends, or you can, like I say, you combine and have two people serving at the same time. And those two people, it could be set up that they have to make a unanimous decision, or that any one of them can act independently. For instance, if one's on vacation or one's not available, the other one has the ability, even though they're serving in a co-role, the other one has the ability to step in and help. So really all you're doing with the financial power of attorney is creating, or the overall purpose is creating a hierarchy of who may assist you with financial decisions, real estate, estate planning, anything related to your financial or business type affairs, if you're unable to make those decisions on your own behalf. Let me just see, we have a question. So a legal guardianship, and we'll talk about guardianship, but yes, it does. There is basically guardianship and conservatorship is a court-ordered version of these powers of attorney. So powers of attorney are a private document, and all that you have to, the requisite capacity you have to be able to create a power of attorney is simply that you know who you are, you understand the powers you're delegating, and you know who you're delegating them to. If you know those three things, then you have the ability to create a power of attorney. So we talked about, or briefly touched on, the healthcare and the mental health care power of attorney as well. At our office, we usually will combine those into, they're two separate and distinct sets of powers, but we'll combine them into one larger piece of the plan. A lot of that's just for ease of use with medical providers. And instead of having to have two different powers of attorney, you have it all in one, but it's all there and properly delineated. And so with this, it's the same thing. You're choosing someone or someone's to be able to assist you with medical decisions, communicating with your physicians, obtaining medical information only if you're unable to. So we talked about with the financial power of attorney, I mentioned that term springing, which again, just to clarify, means that you can, on the financial piece, the financial power of attorney, you can make that active immediately. Or, so a lot of times people who are maybe know that they have a disease or a diagnosis that is progressing, and they know that their inability to make decisions is pretty close. A lot of times they'll set it up so it's effective immediately, just so when they need the help, it's already there and they don't have to jump through more hoops or obtaining paperwork. Sometimes elderly folks with adult kids who they have good relationships with and really trust, they'll just make it effective immediately because it just makes sense there. So it's totally a personal decision. But on the medical side, for the healthcare and the mental health care piece, there's really no option for that. And the reason is the statute, the Arizona law that creates this, says it's not effective immediately, or not effective until you're unable to make your own medical decisions. Now, there's things we can do with the crafting of it that can maybe try to tweak that a little bit, but generally the policy is they want people to make their own, and this is how it should be, make their own medical decisions for as long as they can. One note on the mental health care power of attorney, for those of you who are unfamiliar, there's also a spot on there that under the statute that you need to specifically delegate the ability when you sign the power of attorney, if it's yours or whoever's it is, for admission into a level 1 psychiatric facility. You have to pre-authorize or not when you create that mental health care power of attorney. And it's important to do whatever your preference or the principal's preference is. But if what happens is, a lot of times if somebody is in need of mental health, medical care, clinical services, and they either don't have a mental health power of attorney, or they've done a mental health power of attorney, and maybe it's such that they need admission to a level 1 inpatient psychiatric facility for evaluation or observation. If the principal on that mental health care power of attorney's initial no, then under any of those circumstances, the absence of a mental health care power of attorney or the lack of authorization of that level 1 authority, a guardianship may be required if that need for inpatient admission has arisen or has manifested itself. So hopefully that we'll get some clarity through that, and I'll kind of go over that again when we get to guardianship. And so what happens if you don't have powers of attorney? Are they really necessary? What's the potential backlash? So it's kind of like insurance. You don't need them till you need them. But when you need it, it's too late usually. So again, with the powers of attorney, all you're doing is creating a hierarchy or a system for helping you with decisions when you need them. But getting them in place is important. If you don't have them in place and something happens like a medical trauma or an accident, and you are at a point where you're unable to make decisions and you're no longer able to meet that capacity requirement of knowing who you are, the powers you're delegating and who you're delegating to, then what's going to happen is a guardianship and or conservatorship could be required. Now, we always in the courts nationwide, including in Arizona, have this policy that we want to allow people to live their life and have decisions made for them or with them, or to make their own decisions in the least restrictive way possible. And so powers of attorney are a lot less restrictive than a guardianship and a conservatorship. And so to kind of touch on the last question that we had, the guardianship is sort of like the court-ordered equivalent to a healthcare power of attorney. And then a guardianship with mental health powers is kind of like the court ordered version of a healthcare power of attorney with the mental health care power of attorney. And then conversely, a conservatorship is analogous or equivalent to a court-ordered version of a financial power of attorney. So you're taking what could have been, sort of very straightforward private documents as part of a plan, and then you're coming, if you're having to go the guardianship conservatorship route, and instead getting involved with the court, which can involve a loss of liberties to the person who is incapacitated, and it can be costly, certainly exponentially more costly than powers of attorney. On the healthcare side, there's also, and I mentioned this earlier, there's also a living will that is part of a competent estate plan. The living will is essentially a piece of the plan that allows you to delineate the level of medical care you want, or maybe you don't want, if you find yourself in a terminal disease, in a permanent vegetative state, or a irreversible coma. Now, of course, these are all things that we hope don't happen to any of us or anyone we know. But on the unfortunate chance that it does happen to one of us or someone in our orbit, for that person, it's going to be too late a lot of the times to be able to say what they would have wanted if they were in a permanent vegetative state or irreversible coma. So completing and designing a living will allows you to make those specific end-of-life wishes known and communicated while you're able. And so if you don't do it, what happens is your loved ones are kind of there left to make the decisions for you. And yeah, you may have communicated to them in the past what your preferences would have been in this situation, but they're also now having to remember what those conversations were, also dealing with the stress and anxiousness and anguish of their loved one having some sort of medical trauma or being in this medical event. And even other circumstances, it can create a dispute and involve potentially the court getting involved. I don't know. It's a while back now. It was, I think, in the 80s, the Terry Schiavo case out of Florida, the young woman in her 30s who had some sort of kind of bizarre virus that put her into a vegetative state. She did not have a living will. Her husband and her parents sort of elevated into a dispute about what should happen to her body. At a certain point, after years and years of her kind of at this new baseline in this vegetative state, her husband wanted life support to be stopped. The parents did not. So this went up through all levels of federal courts, and that all could have been avoided if Terry had put together a living will in her state of Florida. So that's kind of an overview of the 3 different powers of attorney, all of which you should have. Then with an estate plan, we also talk about, so powers of attorney focus on decision-making or helping you with decision-making while you're living. A last will and testament is it's a contingent document. It's a contingent piece of a plan, meaning it only kicks in. You can state your wishes and have it set up, but it only kicks in and has authority contingent upon your passing, because what you're doing is you're expressing your wishes for your property when you pass away. And so what a lot of people don't realize is with the last will and testament, it requires probate, which is time consuming and public. A lot of people think you only need probate if you don't have a will or don't have a trust, and that's not correct. If you a trust is a way to avoid probate, which we'll talk about that in a minute, but a will, last will and testament, is not a way to avoid probate. A will also, last will and testament also ignores the possibility of incapacity, because it only kicks in or takes effect, comes to life when you're deceased. So during this time when you may be alive and are incapacitated, it doesn't have any authority or power over your assets or your property or helping you while you're in that situation. And it's also not the best planning for minor beneficiaries, and in a lot of cases also special needs beneficiaries. That's a good question. So the question is a handwritten will recognized as long as it is notarized and signed by the person making it? So that's known as a holographic will. And in Arizona, a holographic will is recognized. However, there's a couple of conditions to that. So it has to be in the handwriting of the person making it. Can't be typed, can't be pre-printed, can't be written by someone else. It has to be the testator, that's the fancy legal term for the person making the will, has to be in their handwriting and signed by them. Now, it doesn't have to be notarized. It doesn't have to be witnessed. The only requirements of a holographic will in Arizona are that it's in your handwriting and your signature, the person making the will. And it's frustrating because we've had people try to do that before and they passed away and their loved ones have come to us and said, hey, can we make this, is this legal? And it's very clear that the person who passed put a lot of thought into their plan, kind of their own will that they made, but they typed it and then signed it, or they had someone else write it and they signed it, or they videotaped it. And so none of those things are binding or legal in Arizona. So the holographic will, I was talking to someone the other day who was in a really bad accident and they were going to have to go through some, it was actually their partner, but the person who was injured was going to have to go through some experimental surgeries that had only been performed a handful of times in Arizona. And they wanted to put together an estate plan, but we didn't have the time because the surgery was the next day. So they were going to try to have her, but she was in so much pain and had some cognitive issues. So they were going to try to coach her to, they knew what her wishes were. She was able to communicate those, but physically it was if she was able to handwrite the will herself was the problem. And so she was able to kind of sketch out some thoughts and then do a signature. So in a pinch or in an emergency like that, it can work. There's even a court case out of Texas where a gentleman was injured in a farming accident. He got pinned under his tractor and he found a rock and he couldn't get out, and he found a rock and he carved his will into a fender of the tractor, and then subsequently passed away before anyone found him. And it went to court, and the court determined that his wishes in the fender, because he sketched them himself, even though he didn't use a pen or a pencil, was a valid holographic will. So not the most recommended way to probably do things, not the most thorough typically, but it is a proper way to do a will, as long as you meet those conditions of it's in your handwriting and your signature, assuming it's your will. Now, conversely to a last will and testament, there's a revocable living trust, sometimes known as a living trust. The nice thing, or there's several nice things about a revocable living trust, but kind of touching on the yin and the yang of the benefits of the revocable trust to the cons of the last will and testament. A revocable living trust avoids probate at death. So as long as your trust is created and funded means your assets are moved into the trust. So if you have a home, your home is titled to the trust. If you have bank accounts, those get moved into the trust. And so there's a way to do all those things that's generally pretty straightforward for all of your assets. But if the trust owns them and you pass away, then probate's avoided. You don't have to submit your will to the court, doesn't become public record. And whoever you've nominated as your successor trustee or trustees to administer your trust when you're gone or incapacitated, that person doesn't have to mess with court, doesn't have to apply for anything. They just jump in and start acting. They just kind of take what you've left them in terms of the rule book. And that's really what a revocable living trust is the big rule book, sort of guidelines for your trustee. So they can just jump in and start administering your trust. So that is paying debts, making sure that funeral expenses and plans are taken care of and carried out, and then making distributions to the beneficiaries and giving information to the beneficiaries and getting them what you wanted them to have. The other, I think, crucial point to make about revocable living trust is, and it's right there in the middle, that term living. It allows you to create a system of someone who can maybe help you with your trust assets while you are incapacitated. So unlike a will, it doesn't kick in until you're deceased. The trust lives with you. And so if you've got assets you've moved into the trust, like a house and some bank accounts, and you are, for some reason, whether it's a medical event, a progression of a disease, or an accident, and you're unable to make decisions, you've got a successor trustee or trustees already named, they're built in, and they just have to step up and start acting on your behalf. And so that's a big, I think, a big consideration for most people, because estate planning isn't just planning for your death, but it's also planning for your life. The trust also provides maximum privacy because it is a private document and doesn't have to, you don't have to get involved in court. Similarly, because you're avoiding probate, there's usually a quicker distribution of assets to your loved ones. There's more flexibility in the trust too, because you can retain assets in the trust for minors, spendthrifts, or special needs beneficiaries. It prevents unintentional disinheriting in some cases. And the other nice thing about a trust is that we can build in some things that create asset protection for your heirs. So if you're leaving money to children or grandchildren, there's ways to build in provisions to the trust that protect their money if they're ever divorced or file bankruptcy or get sued or have creditor issues. So that can be very powerful. A lot of people like to do that, obviously, because they'll say, hey, what happens if my daughter gets divorced or my son gets divorced? Or what happens if my son's always been really bad with money management? What happens if he grows up and files bankruptcy? Is everything I left him when I pass, is that just going to all go with that? So there's ways to set up those kind of protective things. There's just a lot of flexibility in a trust, and like I said before, we could sort of spend a whole day just talking about revocable living trusts, but we don't have that time, so we're getting the compressed version. And Bruce wants to know if a revocable living trust prepared in Arizona is valid in other states. So the answer is generally yes. Most states have a statute that says if a trust was validly prepared and executed per the laws of the state where it originated from, when it comes to whatever new state it's in, it's valid. And that's the nice thing about trusts, is you can almost essentially guarantee they're valid in all 50 states. One thing that we'll sometimes do is a lot of times because so many people migrate to Arizona, we get a lot of calls from people who, I just moved here from Idaho or Washington or Minnesota. I need you to look at my trust to make sure it's valid under Arizona law. And almost all the time it is. Usually the problem is it's outdated and it's not up to date on sort of federal laws and different things, different strategies. So we'll identify those things for them. But one thing that is kind of a state by state issue is sometimes attorneys will prepare trusts that allow the jurisdiction of the trust or the domicile, in other words, where the trust lives, to be based on where the trustee lives. So there's this flexibility built in that just sort of follows you around if you move or if you pass away and your trustees maybe not in Arizona, but maybe they're in Kansas or somewhere else. There's probably a better way to write it, to create it, is to allow that flexibility so it's most convenient to where the trustee's at. I've seen some trusts where I saw one the other day where someone moved from California and it was just like one sentence that the domicile of this trust is California, period, end of story. So there was no built-in flexibility to change that. So sometimes in a dispute that can cause a little bit of sort of a pretzel, but there'd have to be a fight for that. So long-winded answer to your question, Bruce, but generally the short answer is yes, a revocable living trust is going to be valid in every state. But you may want to just look at, if you have one, look at the jurisdiction privileges and make sure that there's some flexibility built in for that. And then this isn't the most eye-appealing chart, but I was trying to come up with a way to like sort of show sort of the pros and cons like all on one slide. So and it shouldn't just be wills versus trusts, it should be no plan versus wills versus trusts. So for most of us now, estate tax planning is kind of irrelevant. And largely income tax planning, there's not a ton that we can do, but there's a little bit in a trust that you can do to kind of help minimize income tax planning. Right now, the estate tax for a married couple is like $24 million. So there's just a handful of people in the country that even applies to right now. There's been talks that it'll lower. And I remember when I first started practicing law, it was $1 million. So it was a lot lower and a lot more people hit that. And the planning that we did more on a more day-to-day basis was a heavier gear towards estate tax planning. But you'll see if we jump over to name someone to handle your affairs when you die. If you do nothing, then the government's going to pick for you. There's a statute that kind of lays out a hierarchy of who's going to handle your affairs if you haven't selected someone. A will and a trust plan, you can do that. In terms of naming who you want to receive assets, same thing. The government will decide if you've done nothing. The government will say, "Hey, we've created a statute that'll help walk through this analysis for you, and you don't get to pick. We've already picked." And then there's a will and a trust. That obviously that's a big chunk of what their purposes are, is to name who you want to receive your assets. Now, real quick, just because I was just thinking of this story, there's a lot of people think like, well, hey, listen, everything's going to work out like it's supposed to, even if we don't have a will or a trust, or my loved one doesn't have a will or a trust, it's all going to work out. And a lot of the times that may be the case. One story that I thought was sort of indicative of this was, I was talking to an elderly lady, and this is now about 4 years ago. And she was like, "I don't have a will, but everything is all set. I don't need it. I'm all good." And I said, "That's fantastic." And I said, "Tell me about your family a little bit." And she said, "Well, I have one son and I have a daughter who passed away. And my daughter had one daughter of her own. So I want everything just going to go 50-50 to my son and to my granddaughter." And I said, "Okay, well, that's good. I'm sorry to hear about your daughter." And I said, "Tell me about your relationship with your son. Do you trust him?" And this is the part that shocked me. She like lurched back, folded her arms aggressively, and said, "I absolutely do not." After I like got over the shock, I'm like, "Well, okay, see, that's a big problem." And I didn't say it to her like this. And I said, "Well, you understand the way the law is set up. If you don't do a will, everything is going to go to your son, and he legally inherits your entire estate. So it's up to you to make that not be the case." But the reason I asked if you trusted him is he would have to voluntarily agree to split with his niece 50-50. And if he chose not to, then nobody could compel him to. And then her eyes lit up and she had panicked. I said, "I'm really sorry, I didn't mean to scare you. My goal is just to help you make sure that this idea, this plan you have is going to be carried out." And so that's just an example of how the government's going to not follow her plan if she didn't take steps into her own hands. And then naming someone to handle your affairs if you're unable to. So a will doesn't do that. If you do nothing, of course, the government's going to decide. A will doesn't do that, because remember, that only takes effect after you're deceased. So only if the trust can you name someone to handle your affairs if you're unable. Asset protection for heirs and beneficiaries. That's what I was just talking about with the divorce protection and the bankruptcy. And then avoids probate. As you see, the only thing that does that is a trust. Avoids living probate. Living probate is a term that a lot of jurisdictions use for if there's a guardianship or conservatorship. So you can avoid living probate through that mechanism. And then it's a private process, of course, not involved. And of these three, the only one where you can make sure the government and the court aren't involved is through the use of a trust plan. Now, there's a question: if someone other than yourself is on bank accounts, will this avoid probate if having just a living will? So a couple things there. I think you meant, instead of living will, I think you meant last will and testament. And a lot of people, everybody confuses those terms because there's the word will in both of them. So I wish when they were created, which was before me, there would have been a little more distinction. But a living will is the part of your plan where you're kind of delegating or delineating what medical treatment you may want or don't want if you are in a coma or a vegetative state. So if someone other than yourself is on your bank accounts, this will avoid probate. The reason why is there's a law in Arizona that assumes that any bank accounts with more than one person on them creates right of survivorship. So a lot of people own property. You can own it with your spouse or a child or a friend as right of survivorship, which means when you pass, the surviving owner gets your share. So that same thing is assumed on all multi-owner bank accounts. So what that means is if you've got someone else, like a child or a sibling or a friend on your bank account and you pass away, that account's theirs. Where that can sometimes run into trouble is, and I see this a lot, if you've got multiple kids. So a lot of times people have multiple children, and there's a child that they have a better relationship with, maybe because it's proximity, they live close by, or they see them, or they're more supportive in the day-to-day lives, or maybe they're more responsible with finances. And so for one or more of those reasons, they'll say, "I'm going to put my daughter or my son on the bank account with me." And that's just going to make it easy. If they need to help me, they can go in because they're on the account. But one thing you have to be aware of you have to understand it, like we had this come up once where there's 3 kids. One kid was on the account with mom. Mom passed. So mom originally had a trust, and this daughter moved money out of the trust, opened up this new bank account, put herself on it with mom. Mom passed. All this money that was supposed to go a third, all went to daughter. And the bank was legal in giving it all to the daughter. So there was some challenge that came into place where the other 2 kids took that daughter to court and said, hey, you made some maneuvers here that took advantage of mom, and you unduly influenced her, and some issues that the court had to sort of work through. But it is a way to avoid probate. And I'll often suggest that. Like, I had a gal who called me who has an only child, and her financial planner referred her to me, and her financial planner that she uses is very big on his philosophy is everybody has to have a trust no matter what. So she called me, she's like, my financial planner said to call you and that I have to have a trust. I said, well, let's talk about that. See if you really have to have a trust. So it turned out she has an only child. She had a condo, checking and savings, a vehicle, and a retirement account. And that was the totality of her estate, which is quite a bit. But I said, you know what? You don't really have to have probate, or you don't have to have a will. We can set our trust. We can set this up so you can avoid probate. And we didn't put him on the account, because the other thing I'll mention real quick with putting a loved one on an account is they could also be liable for, you're kind of commingling your finances, so there could be some liabilities there. And also, if you have a falling out with that person who's on your account, they do have access to take from it against your will as well. So it kind of can complicate things, but technically it is a way to avoid probate because of that titling and that right of survivorship. So that's kind of what I wanted to touch on with estate planning, a very sort of 10,000-foot view. Now kind of going into guardianship, because I put it here because we mentioned that if you don't have powers of attorney and someone's incapacitated and there's a need to help with decision making, guardianship may be the remaining option in a lot of cases, and conservatorship. So when I'm saying guardianship, conservatorship's also sort of built in here because the process is the same. But basically, as I touched on earlier, it's a court action to protect an incapacitated adult who needs help making important life decisions. Now, sometimes we have children who we know we're going to need help with decisions when they become an adult, when they turn 18. So for a minor, you can start this process at 17 and a half years old. You can start the application to the court at 17 and a half. That way you build in time so that by the time they're 18, you've got that framework in place to be able to help them with any decisions. So what is a person who is incapacitated? How is that defined for purposes of a guardianship or a conservatorship? Basically, it's someone who lacks sufficient understanding to make or communicate responsible decisions because of a developmental disability, a mental illness, a physical illness, or chronic use of drugs or alcohol. And sometimes there's a crossover. Sometimes there's multiple of those things in place, but there only has to be one of those that results in a lack of sufficient understanding to make or communicate responsible decisions. As I kind of touched on before, guardianship's a big deal, and we've seen it in the news more with Britney Spears, and there's a Netflix movie and some other things that kind of put it in kind of highlight some of the abuses that can occur, and that's why there's a lot of framework of checks and balances that have been put in place in most states, Arizona included. And so the person who is petitioning to be the guardian and or the conservator, technically you're taking away that alleged incapacitated person's some of their constitutional rights. So there's a lot of things that have to happen, and there's a lot of legal paperwork that has to be prepared, filed with the court. There's evidence. The court will generally appoint an investigator. The ward or the alleged, I don't love that term, the ward, that's what the court uses. But the alleged incapacitated person has an opportunity to object, and they're appointed an attorney to do that. And there's always a hearing. in a lot of circumstances, we can use a limited guardianship, and that's if the there's just sort of a limited focus on what needs to be done. Maybe it's a temporary thing, or maybe it's going to be longer term, but we want to make sure that the alleged incapacitated person isn't going to lose all of those constitutional rights. So if they are able to continue driving, and or if they want to retain the right to vote, the Arizona Constitution says that people that are under guardianship lose these rights, and the government has to basically change our state constitution to change that. So a way around that is through using a limited guardianship, which allows that to be retained. And we've had a lot of folks that we've helped them and or their loved ones through the court process where they're unable to make their own decisions, and they definitely need a guardianship and or conservatorship, but they're also able to drive and or vote. And so, a lot of people who are outside of this don't see this every day or don't live in this world. They think like, well, if you need a guardianship, there's no way you could drive or vote either. And that's not always the case. That's being a little bit stereotypical. And so I don't want to spend a lot of time on the slide, but basically there's a lot of paperwork that has to go through. One thing I didn't mention is there's a physician's report that needs to be prepared with the petition. And the reason the physician's report is needed is you need some medical evidence to show the court, to prove to the court that because of either developmental disability, a mental illness, physical illness, or chronic use of drugs or alcohol, that this person's unable to safely make their own decisions, and the court has to, rely on that clinical evidence to meet that burden. In a guardianship, there is in the statutes there's a priority for appointment, and this basically says, if there's been no other kind of indication of who you prefer to be your guardian or your conservator, the statute says here's the priority. First, it's your spouse. Second, it's the parents. Third is an adult child. Fourth is a relative caregiver. Now, there's actually a first here that jumps over spouse, and that's the person that the alleged incapacitated person has nominated. So that's another in the powers of attorney that we prepare for people. Generally, once you have a power of attorney, and that's the beauty of it, you're not going to later need a guardianship and conservatorship except rare, limited circumstances. But we always, in our powers of attorney, in the financial, we build in a built-in nomination for conservator if one was ever needed. And in the healthcare and the mental health care power of attorney, we have you build in a kind of advanced nomination for who you'd want your guardian or what people you want your guardian to be, if on some rare instance it's ever needed. That way, fast forward, life changes, circumstances change. If something happened that somebody filed a petition for guardianship or conservatorship, your nominated person has priority, and you've already nominated them in the powers of attorney that you've done. So that's just kind of another reason to do thorough planning in advance if different things change. Now, for like divorced parents of minors, there's always equal priority, so the court will usually appoint parents together. We kind of talked about some of the characters involved in a guardianship. So there's the physician who does the report. There's the proposed guardian, who a lot of times, especially if they're trying to do the paperwork themselves, is overwhelmed. Most of the courts, the county courts around here, Yavapai included, have self-help packets. I think Yavapai refers a lot of people to Maricopa for the packets as well. But they're really kind of confusing, and they're not the most well put together. I know the court was working on changing them right before COVID, but I think that sort of took a back seat. And I mentioned that the alleged incapacitated person gets their own attorney appointed, and there's a court investigator appointed who's basically just serves as the eyes and ears for the court on the ground. So they'll reach out and talk to the proposed guardian, the alleged incapacitated person, and then be able to provide a report back to the court. So the court feels like there's some other outreach that's kind of out there taking stock of the facts and the circumstances. In the court, like I said, they submit a report. The court investigator submits a report back to the court. Court-appointed attorney we talked about, or the healthcare professional. The only thing I'll mention here is that there's a form for the physician's report. If you are seeking mental health powers as part of the guardianship, it has to be completed by a psychiatrist or psychologist, and they have to say that inpatient mental health treatment is needed, and that has to be renewed annually. If mental health powers aren't needed or aren't relevant, then it can be signed by a nurse practitioner, or a physician. So that's the one distinction I wanted to point out there. These are some of the kind of the procedural things. And I'll make these slides available so they can be shared. So the ones that I kind of go through maybe a little quicker in the interest of time, we can have, I'll make sure that everybody has access to a copy of these. So notice there's kind of more legal provisions you have to go through to notice the guardianship. And then court timing. Generally, it's about, right now, it's about 5 weeks out, 4 to 5 weeks out. If there's an emergency, meaning you can state why it's necessary to have guardianship or conservatorship orders quicker, the court will often set those within 7 to 10 days if they believe that there truly is an emergency. These are just some papers that you get from the clerk after the guardianship that are essential. The hearing itself. And then there's mandatory training that has to go along with the guardianship and conservatorship. Went over. So real quick, a distinction here, and I kind of mentioned this, but just to reiterate, the guardian is not a conservator. So a conservator is who manages the ward's assets. And usually the guardian and the conservator is the same person, but they're two different offices that you have to, and if you want to be able to, so if it's somebody that has more than $10,000 that is the alleged incapacitated person, then you're going to need to file for guardianship and conservatorship. And again, just to note that the guardian may also be the trustee for the ward. If the ward or that alleged incapacitated person had a trust set up previously and you were their successor trustee. So a lot of times we can avoid a conservatorship if somebody had a trust, all their assets in the trust, and there's a successor trustee, and then there may or may not be a need for the guardianship. But again, usually with a pretty well put together plan, these offices will be, or these guardianship conservatorships can be avoided. And we talked briefly about, I mentioned the mental health powers on the guardianship, and a lot of you may have familiarity with these already. But it's the ability to admit the alleged incapacitated to a level 1 inpatient behavioral health facility. And again, it only lasts for one year. And so this is very much analogous to when I mentioned on the mental health power of attorney, there's a specific notation you have to make on the power of attorney on the mental health, whether you're delegating this ability to your agent under your power of attorney or not. So you'll see that regardless of whether you're doing it as a power of attorney or through a guardianship, there's always that extra step that has to be taken to allow for admission to a level 1 behavioral facility. And those are just, just having checks and balances in place for that. Jump ahead a little bit here. So kind of shifting gears to public benefits. And so mostly what we're talking about in this realm, as we kind of get into the special needs trust side of things and the different benefits that we're protecting, there's kind of a few benefits that are worthy of mention. So there's Social Security Disability, SSDI, or childhood disability benefits, or sometimes it's called adult childhood benefits, have to qualify as disabled. So there's a medical eligibility, and you have to be fully insured, and it's based on your own work history. So as when you have a paycheck and you pay into FICO, that's you're paying into that Social Security disability insurance system. And so you have to have a number of insurable quarters, and any adult who works most of their adult life is going to be fully insured. And there's a exception for children who were disabled before the age of 22 and have a retired, disabled, or deceased parent who is fully insured, which is a really powerful benefit that not a lot of people know about. So if there's a child who's disabled before the age of 22, when their fully insured SSDI parent retires, that child is going to get 50% of the parent's benefit as well. So the parent still gets their benefit, and the child gets 50% of that. When the fully insured parents are deceased, the child will get 75% of that SSDI benefit. And if both parents were fully insured, it would be 75% of the higher. So that's a nice benefit that can help in an unfortunate situation of a developmental disability. And one big distinction is SSDI and the adult childhood benefits are not based on financial need. It's simply medical eligibility and being able to have met that fully insured criteria. And then Medicare, you have to be over age 65 or entitled to certain Social Security or railroad disability benefits for 2 years or diagnosed with end-stage renal disease or ALS disease. And if your eligibility is based on that Social Security or railroad benefits or disability benefits for 2 years, you have to wait 5 months. There's a little waiting period there. And again, Medicare, as most of you know, is not based on financial need. So then we look at Social Security income or SSI. For this, you have to be over 65, blind or disabled, and there are some financial eligibility requirements. You are limited to $2,000 in countable resources, $3,000 if married. Home, vehicle, and personal effects are not included in that $2,000. That's one vehicle in that $2,000. And then there's a federal maximum benefit, and they just announced it. It's going up for next year, but for the rest of this year, it's $841 a month for a single person and $1,261 if you're married. And then there's a 1/3 reduction rule for the receipt of help from other people on the benefits. And then if you have income, it can also lower your benefits based on the income. But most minors typically are not eligible for SSI because the income and resources of their parents, or if you're married, your spouse, are deemed to you. And so a lot of times, this for children who are developmentally disabled, they're not going to get these benefits until they're 18, and that deeming, meaning their parents, the attribution of the parents' finances to the child no longer occur. And on SSI, once you're eligible, you're automatically eligible for Medicaid or access benefits in your state. And then Access, which is a separate benefit, provides medical assistance for indigent folks who meet the income requirements. And it basically provides health insurance to those who are disabled and eligible for SSI as well. And they also provide medical and long-term care assistance for those that are eligible. And there's a couple different program contractors in Maricopa County who provide the kind of administer or provide the insurance services. This is a way, I just came up with this kind of sort of rudimentary, but it's a way to sort of visually understand where these benefits kind of flow, how they flow. So things that we're entitled to are Social Security, disability, and Medicare. So if we're disabled, as long as you've had those work credits, then you're entitled to Social Security disability, which is cash assistance, meaning they just provide you with a replacement income, essentially, or a portion of replacement income. Then you're also entitled to Medicare once you've met those requirements of being age 65 or one of those other categories of disability, and there you get medical assistance. That's kind of converse to needs-based benefits, where the SSI we talked about, where you have to have disability and financial requirements. So there has to be that demonstrable need. And again, SSI is just cash, not a lot, but it's a little bit of replacement cash per month. And then Medicaid through Access, if you can qualify for it, that provides medical assistance. So there's entitlement benefits that provide cash and medical, and the needs-based that provide cash and medical. So often, and I'm not going to go too deep into this SSI, how to apply slides, because you'll get all this. But when we talk about special needs trust, the main reason for creating it is to protect those benefits. So we've got somebody who is currently eligible or may likely be eligible in the future for benefits. We want to make sure that they are able to, I'm just checking to make sure I'm good on time, that they're eligible to stay on those benefits, but also get money for one reason or another. So a lot of people say, or will ask the question, how do I create a special needs trust? Like what needs to be done? And so a couple questions I put up here are, can you create it during your lifetime? Can it be created after you pass away? The answer to both of those is yes. Essentially, a lot of it depends on the type of special needs trust. And there's a couple kinds that we're going to go through, but they can be created during your lifetime, and they can be created while you pass away. And I'm going to weave that in as we talk about the specific kinds. But and this is the core point, the core reason for a special needs trust and why it was created by federal law, and that is that assets in a properly drafted special needs trust, sometimes called a supplemental care or a supplemental needs trust, and those are just synonyms, are not counted in determining eligibility for SSI and all tax and access. So, and I'm purposely going backwards. So here, where we talk about SSI being limited to 2,000 incountable resources, so that's what we're looking at. We don't want things in a special needs trust to be counted towards that resource that Social Security has for SSI, and also that all tax, that Access has for all tax benefits when relevant. Now, the trust and the assets in the trust have to be reported to Social Security and Access, and there's hoops we have to jump through. And again, that also depends on the type of special needs trust, which we'll get to in a moment. And then the type of trust will also affect how the trust can make distributions, and kind of within the context of SSI and Access of all tax. So the trustee of a trust, of a special needs trust, whoever that trustee or trustees are, they have the sole discretion. The power is in their hands as to the time, amounts, and purpose of any distributions. And part of the required design for special needs trust that we have to satisfy with the government is that the beneficiary cannot have any demands to be able to access the funds. They can't say, hey, I need this, or hey, I want this. They can request. That's a big distinction. They can request, but they can't have a demand that if they say, I want this $500 for this, that the trustee has to do it. It has to remain, the power has to remain in the trustee's hands. The beneficiary, we actually want them to, we want them to have as much independence as possible, but they can't be the final arbiter of whether something is paid out to them or not. And like a lot of different mechanisms where we're trying to protect a benefit in kind of this planning context, there's always sort of a give and a get. And so by nature, the get is or the give is we're giving up a little bit of loss of control over those funds that are owned or that belong to the disabled beneficiary. But the gets that we're getting back for that give as part of this give and get is we're able to protect or insulate all of those funds in the special needs trust from being countable for these very important benefits that someone's on or may be on or may need to be on in the future. And so they kind of get both worlds. The benefits are still, they maintain that eligibility. And then also we're able to have the assets in their name. I met with someone a couple weeks ago who, and this is just really bad advice in this day and age, but they have a estate planning attorney who's in Glendale, Arizona, and he told her she has 2 sons, and one of them is deceased, and the one that's living is 61 years old, and he's developmentally disabled and from childhood, and he's most of his adult life he's lived in a group home where he resides today, and her spouse predeceased her, so her only like kind of nuclear living relative left is she's in her 80s, is her 61-year-old son who lives in the group home. And the next closest relatives are 2 nieces from her husband's side of the family, so her 2 nieces to her by marriage. So she was advised by this estate planning attorney to write her son out, to write him out completely, and leave everything to the 2 nieces with the hope and the prayer and crossing the fingers that they're going to provide for the son. And I was almost jumping up and down in my conference room, like telling her this is awful. Like this is not this is bad for my blood pressure, but more importantly, it's bad for your family, and it's really, really bad for your son, which is the key reason my blood pressure was elevated in that moment. So I was trying to tell her that, and her attorney just didn't have the knowledge, and that's okay, about special needs planning. And so to him, the solution was just, let's not screw up his benefits, so let's give it to someone else. Well, that's the whole point of the special needs trust, is to allow it to be in the son's name and to be used for him. That's what as a mom, I think that's what she wants. But she was so stuck in this idea of, or so, I guess not stuck, but unifocused on this concept of not screwing up her son's benefits, which he really needs. And so there was a way to get, funds into his special needs trust to really enhance his life, while keeping his benefits. So I don't know that she's going to do it, which worries me a little bit. But that's just an example of what not to do anymore, because you don't have to. That's the beauty of the special needs trust. And so I kind of teased earlier that there's different types of special needs trust. The type that you use largely depends upon where the money's coming from. So whose money is it? Is it, an inheritance, a settlement, a gift from an accident? Those are all relevant inquiries to determine where the money should be put and what kind of special needs trust should be used. And there's a question I want to get to in just a second. But first party special needs trust. So this is money. So the term first party, that means it's money belonging to the special needs beneficiary. It's their money. They're the first party. And so generally, the way their entitlement to money happens, thereby creating the need for a first party special needs trust, is through a settlement. And that's largely how it can happen. If someone's injured and they have a settlement or a claim, through an inheritance that's maybe not totally properly planned out, through retroactive pay, maybe it's through government benefits of some kind. These are all things that belong to the beneficiary, the individual. So you have to plan a first party special needs trust for these. And essentially it's the disabled, if they're assets of the disabled beneficiary or beneficiary spouse as part of a personal injury settlement. Now, the major kind of negative to a first party special needs trust, although that negative is always almost outweighed by the ability to protect those funds, whether it's from an unplanned inheritance or a settlement or retroactive pay. The alternative is to not do a special needs trust at all and lose your benefits, and that's not a viable solution in most cases. So you do the first party special needs trust. However, and again, this is the one drawback, kind of the exchange you have with the government and doing a first party special needs trust, is this payback provision. And that's required to be included in all first party special needs trusts. So what happens is at the beneficiary's death, the state Medicaid agency, with Arizona is probably most relevant to most of us, has to be paid back for their lien in full. So for the capitulated rate of everything they paid in care for that person when they pass, they say, hey, here's our total lien. We want to be paid back. So as to any assets in the first party special needs trust, the state gets the first bite. They get to come in and say, hey, we're owed 100 grand, 200 grand, 20 grand, whatever it is, but nobody's got priority in front of them. And with a first party, there's also a little more scrutiny or review by the Social Security Administration. And so they're going to review it to make sure that the person was under age 65 when the trust was established or funded, make sure it's assets of the disabled individual, that the disabled individual is the sole beneficiary, that it was established by a proper person or court, and does the trust provide that specific payback language. And so Social Security will make sure that that's all there. If it's not there, they'll reject the trust and it'll have to be reformed. You have a certain amount of time to reform it before you're really in danger of losing the benefits. And then pooled trust, which is also a type of first party special needs trust generally, but the nice thing about a pooled trust, or what the purpose of it is they're nonprofits, and there are several around the country, but they basically create a master first party special needs trust, and people can pool into them, and they create like joinder agreements. So you just kind of sign a joinder to join into their pooled trust. Where I typically use pooled trust or recommend pooled trust is if somebody has a personal injury settlement for a small unplanned inheritance, and we're talking like, a smaller amount of money, and I use that with a grain of salt, like, 100,000, 150,000, which is a lot of money. But over the course of a lifetime, it's not a lot of money for somebody, especially who has, higher level medical needs. If it's a smaller amount of money, I typically won't recommend spending the time and money and resources to create a whole new separate first party special needs trust. Identify a trustee and go through all that work when they can just join into a pooled trust for a smaller amount of money. That generally makes more sense. If it's a higher level dollar amount, then we'll do a separate first party trust as opposed to the pooled trust. Okay, we have a special needs trust within our family trust under the heading of distribution. Is this acceptable, or do we need a separate special needs trust? I'd have to look at it to know for sure based on what you told me. However, the answer I will give is it's likely okay. And so remember a couple slides ago regarding special needs trust, I mentioned that I kind of teased a couple questions that can this be created now, or does it have to be created upon my passing? Both are ways to do it. So if you've got your own living trust, if you're married and you and your spouse have created a living trust, and you've got a special needs beneficiary like I do, I've created a special needs trust for my daughter. Now you can do that in your trust in what we call a testamentary trust, meaning, and the way I explain it to people is, think about, so you got your trust, and think about, you put inside your trust this deflated balloon that is your loved one's special needs trust. And it's a balloon, so we know what it looks like. We know it can take shape. We know it can blow up. We know what it's going to look like when it blows up. But right now, it doesn't have the air it needs, and it doesn't need the air. But when you and your spouse pass, whatever share of your trust estate you've left to the special needs trust, whether it's all or half or a third or quarter, whatever, it's directed to go into that balloon, that special needs subtrust, sort of blow it up. And then it takes shape. We know what's in it. We know what to do with it. And that's a proper way to create and fund a special needs trust. And then whoever you've nominated as the successor trustee, their job is to just administer it per the rules. The other way to do it, which is my preference for a number of reasons, but there's nothing wrong with creating it in a testamentary trust. That's a valid way to do it. The other way is to create a standalone trust. And that is, it's its own trust, not built into yours. It's not that deflated balloon. It's its own trust there now. The reason that I like that a little better is you can create. So usually with a testamentary trust, where you were under and the person who asked the question, under your trust, it says distribution, and there's a special needs trust. Usually there's not a lot of terms or rules or information. It's just kind of, hey, this is where things go. And so you don't have a whole lot of guidance. With a third party or a standalone third party special needs trust, and both of these that we're talking about right now are third party, whether it's inside your trust or a standalone third party special needs trust, because you're taking a third party's money, you're taking your money that you want to leave to your loved one. So whether you're doing it inside your trust through that little built-in, deflated balloon that's going to wait, or whether you're creating a whole separate piece of the plan that's, your daughters or your sons or your granddaughter, grandsons or nephews, or whatever special needs trust, you can make it a little more robust and create more terms to it, and it's a little more clear. And also, if they're going to get gifts from other people or likely an inheritance from other people, then everybody that's in your orbit and your family can lead directly to that standalone trust. If you've got the testamentary trust, that deflated balloon approach inside your trust, the only person who can leave assets to that is you, because it's your trust and you're feeding into this sub trust that's living in yours. No one else can interfere or break into your trust. So I had a family earlier this year who was getting $500 gifts. They have an 8-year-old son with Down syndrome, and they were getting $500 gifts every year for Christmas from grandma. And then another grandpa passed away and left $65,000 of life insurance specifically to this kid. And so we had to kind of set some things up. So I said, hey, it's too late to put these things in a third party because they already belong to the child. But from now on, let's set up to protect the rest of the money a little more. Let's set up a third party trust and have all the gifts directed there. And mom and dad, you can leave in your trust, specify that your share for your son goes into his standalone third party trust, and let all your siblings and your parents know that any gifts or inheritance they leave for him also feeds into that same trust. So a lot there. It's confusing, but the nice thing about planning ahead and creating, if you know that you've got a beneficiary who's special needs beneficiary because they're on government benefits or likely to be on government benefits, you want them to have those protected. And by planning ahead, you can create this third party special needs trust, which, as I bolded here, has no payback requirement. So at the beneficiary's death, you can create what happens to the assets. It goes to the beneficiary's siblings or charity or other family members. It's a much better way to plan, and more, you can guarantee more money is going to stay in the family, and you're going to have to jump through a lot less hoops. So to the extent you have, that's the one takeaway that the number one takeaway I send out today is if you have beneficiaries who are likely to be on government benefits or have the need to be on them that are means tested, that are going to look at their resources and potentially income, it's best to plan ahead and create the third party trust because you're avoiding that payback provision and a lot of the hoops that you have to jump through. I'll just hit a couple questions real quick. Okay, so I've got about 5 minutes left, then we'll stop for announcements. I can go a little bit longer too, after the announcements are done for people that want to stay on after, so we can get through everything. So again, this is just kind of an overview of the difference between the two. With a first party, meaning if you're leaving money to someone and you didn't set up a plan, they're going to inherit that money. It's going to be theirs. They're going to have to then set up a first party special needs trust, and you have stricter reporting requirements. You have to go through a budget process with access. You have all the distributions have to be approved. For a third party, all that goes away, then and the payback. So there's a huge advantage to try to plan ahead. Now that's always not possible. Like there's like I said, like a settlement or something. And then special needs trust and designing it, there's always thoughts about who's going to be the trustee. Usually it's a family member, it doesn't have to be. There's a lot of complex things that have to be considered, like tax returns, handling reporting to the benefit programs, making sure you're comfortable with the benefit programs reporting requirements. Oftentimes you can work together with a corporate entity, but those are all considerations that can be made and discussed when you design a special needs trust. And the pros and cons are families members are generally more cost effective. They of course have a deeper love and understanding of the beneficiary's needs and preferences and what they want, and it usually provides for more flexibility. And then non-family members like banks, family friends, licensed fiduciaries, professionals, again, they lack a lot of that understanding. It's less cost effective, but they understand usually like the benefit programs, taxes, and different things like that. So these important points are all things I went over. Reporting requirements, sort of just be aware of those, that there are reporting requirements. It depends. Budgeting is really only an issue if you have a first party special needs trust, and you have to create that budget with access. And then distributions are a lot tougher on the first party special needs side. And then in a special needs trust, the things that you can use the funds for are plentiful. But there's a couple that I want to go over, things that you can't or shouldn't use the funds for, or you can, but you just want to be sure that they reduce or be aware that they'll reduce the benefits or make the trust countable. And those things to be aware of if you're paying for basic shelter related expenses, either from the trust or some other person gifting them funds for that, paying for food, cash distributions directly to the beneficiary, or paying for services already provided by another source. and distributions not for the beneficiary, which would be like gifts or distributions made for other family members. And that can come up sometimes in the context of a special needs trust owns the family house, and maybe it's a minor or a young adult, but the family lives there. There can be an issue if the whole family's living there for free, no cost, and the special needs trust is paying for it. The Social Security Administration may say, hey, you're making distributions from the trust for the benefit of the other. So there may need to be some rent being paid back to the trust in a circumstance like that. But this is a long list and I won't go through it because again, I'll share these materials of all things that are appropriate, permissible distributions from a special needs trust that won't cause any issues or potential reductions in the benefits. These are all fair game for making distributions on. And then it continues to all of these things as well. One of the things I was asked to talk about was a letter of intent. And I think I can get through this real quick before we turn it over for announcements. Basically, a letter of intent is a supplement to a trust, a special needs trust specifically. And it serves as a guideline or kind of feedback for those who may have responsibility for the beneficiary. I work with a couple right now. They're in their late 70s. They have a daughter who's 41, who was born with a really bad birth condition, birth defect, a hypoxic brain injury. And she's been in a wheelchair and needed 24/7 care her entire life. And they're getting old, they're having health issues, and they are scared to death of what's going to happen to her when they're gone and who's going to care for her. And so I worked with them to put together probably the most specific and detailed letter of intent we've ever done. And it's just because they want all this information out there to make it as easy as possible on the person caring for her and making sure she gets what she needs and is as comfortable as possible. So when you do it, all the nuclear family members or the person that know that beneficiary should participate, and you're documenting expectations for the future. And defaulting preferences should go towards enhancing independence and growth, not restriction, but enhancing those things. And it's not technical. It's not a legal document per se. So it doesn't have to have all that technical info that a special needs trust may have. And this is just an example or a list of some of the things that should be in a letter of intent. Some basic bio on the beneficiary, who the relevant helpers are, family, physicians, therapists, attorneys, support groups, case managers, etc. What sort of financial support the beneficiary is receiving, the current living arrangements with those preferences and routines, and the programs and services that they're involved in on a day-to-day, week-to-week, month-to-month basis. Personal preferences for grooming, food, recreation, religion, their abilities for transportation, financial, communicating, kind of all the relevant aspects of their disability and how they affect those activities of daily living or the executive activities of daily living. And then the letter doesn't have to be anything fancy. Just all those things should be in it or combination, signed and dated. I've told families sometimes they're like, because you're in the moment, you're in the day to day, so you don't always know what should be in the letter. And so I recommend keeping a care journal if you're struggling for several weeks, and then you'll have kind of a roadmap of what you're doing or what's been going on, and that can help inspire the letter. And if you've got estate planning documents, keep a letter of intent with it, and then share the letter with those who may be responsible, those people you've named to help care for the beneficiary. And then as things change, remember to review and update the letter when relevant. Okay, so ABLE accounts. This was just based on a federal law. That the term ABLE came from Achieving a Better Life Experience Act of 2014. What this was essentially it was designed to be the kind of thought of the equivalent of a 529 college savings plan, but for disabled folks. So you had to be disabled before the age of 26. And just as a side note, there's a law currently, or a proposal currently making its way through federal Congress that would update this to age 45, which would be very helpful. And I think the goal is eventually to get it to 65. But right now it's 26, and it's individuals with a disability who meet the Social Security standards for disability, that definition. And again, that disability began before the age of 26. And what it is for is it allows folks, disabled folks, generally with a developmental disability, to save money, spend money on qualifying disability expenses without losing public benefits. So as long as the money, and we'll go over some very brief financial contribution rules. But as long as you're within those contribution rules and money that comes out is spent only on qualifying disability expenses, which are very broad, that covers a whole lot of things, the money grows tax free. So there's no capital gains taxes that have to be paid on those funds. And the money that's in the ABLE account up to a certain dollar amount is also kind of invisible from government benefits and not counted. Therefore, you don't lose the public benefits. So who can open an ABLE account? So it's an individual who's disabled themselves can open it, a parent, a legal guardian, or an agent under a power of attorney. And you can open it in any state. So you don't have to open it. Every state has an ABLE account, but you don't have to open it. And for instance, if you live in Arizona, you don't have to open it in Arizona. You can use another state's ABLE program. And some have more favorable provisions than others, but they're very minimal. They're not, one's not extremely better than the others. And every state sets a minimum initial deposit. In Arizona, it's $50. The annual maximum contributions right now are $16,000 a year from any source. And that's going to go up next year to $17,000, and $12,880 from account holders' individual earned income. So what that means is that if somebody who otherwise qualifies for an ABLE account is also employed, they can contribute, whether it's from themselves, a gift from family, from parents, or whatever. They can contribute up to $16,000 and up to $12,880 of their income. So for instance, if they only make, say they only make $6,000 a year, because they, very minimal income, just from very spotty work, they can only do up to $6,000. It has to match what their income is. So it's a way to kind of let them contribute some of their income, almost kind of like a quasi 401k, but into the ABLE account where there's not that taxation that's gonna grow, as long as it's coming out to be used for qualified disability expenses. Now, the maximum lifetime benefit, the most that can be contributed over the course of a lifetime to an ABLE account, is $550,000. However, that's a big warning, because most public benefit programs have account balance limits. So under SSI, they're going to anything over $100,000 is countable. So you're going to risk losing benefits if you go over that lifetime or that total balance of $100,000. So generally, for somebody who's on public benefits, there's only a handful of years that the contributions can be made, unless money is also coming out for qualified disability expenses. And again, anyone can put money into the account. There's no restriction on that. It can be used for almost anything. The qualified disability expenses is a huge category of definitions of things. And there's no reduction if it pays for shelter. So that's a key kind of strategy thing. So a lot of times what we'll do, because if you remember from an earlier slide where I was talking about what distributions from a special needs trust can be used for, and under the SSI rules, if the funds from a special needs trust are being used to pay for shelter or food, that creates a reduction in benefits, generally not an elimination, but a reduction. Because the policy behind that is Social Security is saying, hey, we're paying you money every month. That's supposed to be used on your shelter and your food. If you have other monies that you're using on shelter and food, then you don't need all the assistance from us. Which of course is kind of a silly thought, because it's not very much money, especially with inflation, how it is today. Living is very expensive. But that's the rules as they stand today. So without getting too complicated, a lot of times what we can do is set up a kind of a plan where there's a special needs trust in place, and the special needs trust can make distributions to an ABLE account as long as they're within these dollar limits of $16,000 per year and no more than $100,000 if we're trying to preserve the benefits. But then what can happen is the beneficiary from their ABLE account can use that money to pay for food and shelter as a supplement and not reduce the benefits. So by adding an ABLE account onto the plan and filtering money from the special needs trust to the ABLE account, which is permissible, and then jumping over to the ABLE account and using it to buy these things that would otherwise be penalized if they came out of the special needs trust, but instead they're coming out of the ABLE account and paying for shelter or food if necessary. So that's a way to prevent that mitigation or lowering of benefits. It's complicated, it is, but it's just thinking creatively and long term and looking at it as kind of a, he hates to treat it as a game, but it can often be some kind of a bit of a chess game with trying to do different things to maximize the benefits, preserve them, but also maximize the independence and the things that the special need beneficiary can access under those circumstances. And then the one negative piece, again, kind of goes back to that give and get that we see. You're getting all these benefits from the ABLE account. The one thing you're giving up is that at the beneficiary's passing, the person whose ABLE account it is, when they pass away, everything that's in that account is subject to the Medicaid payback, just like we talked about in the context of first party special needs trust. That also applies to ABLE accounts. So you just have to be cognitive of that. But if there's not a lot in the ABLE account, if a beneficiary's, where it's maybe more of a problem is if there's a sudden passing of the beneficiary, but if the beneficiary's has a known condition or is older, usually you can plan to spend that money down so it doesn't, not all available to the state. But that's something to think about too if you're taking a third party special needs trust, whether it was created by a loved one's trust after they passed, or it was a standalone trust created by a loved one on that beneficiary's behalf. Remember, we talked about the third party trust doesn't have the payback provision. So one thing to be careful about is if they're on SSI benefits and they've got the third party trust, you can, it still makes sense to take money from the third, if they need assistance with food or shelter, to take money from the third party special needs trust, feed it into an ABLE, so then the person can use the ABLE account to take care of those things without any reduction in their benefits. But just one thing to be considerate of or consider is the third party special needs trust, remember, does not have a payback provision. So while on one hand you're getting a benefit here for food and shelter payments by putting it into the ABLE account, you're also taking on a detriment that's not in the third party trust, and that's the payback provision that's in the ABLE account. So it's like a pretzel, but hopefully that makes some sense. And it's just, there's no wrong or right there. It's balancing all those considerations when assisting somebody. And we just talked about how they can work together. So it's a lot. It's kind of the takeaway. Don't be overwhelmed. Everybody's walked, not everybody, but a lot of people have walked this path before you and been fine. There's a lot of resources out there. And then thinking about it like, if you don't have a plan, or if you're thinking about creating a plan or supplementing a plan, or you have a plan and you think it needs to be reviewed and updated, just focus on, one foot in front of the other. And don't believe everything you hear. There's a lot of myths and bad information out there. So I think that was it. So fortunately we didn't go too far over. I was close to on time, close-ish. I again, not to sound like I'm beating a dead horse here, but this is a lot of information. So I kind of fire hosed everybody today. So I expect some heads to be spinning, but I wanted to kind of take the challenge and address a lot of the information that was asked of me to present by Candy. And so hopefully hit on most of it to some degree, but certainly here's our phone number and our website. We're available if you ever have any questions or just want to follow up. And if you call the office, just say, hey, I was on the presentation that Caleb gave with Yavapai NAMI, and just had some follow-up questions, and they'll get you connected to me. I can also share my email address. It's Caleb, it's my first name, CALEB, @taylorlynn.com, just like it's there on the screen, but just substitute Caleb for www and then put an @ for the Taylor and Lynn. So I hope everybody took something from this, and it can help you in kind of figuring out what you were going to do or need to do, or steps you may take, or questions you want to explore. Again, thanks for the opportunity.
Well, and thank you, Caleb. And I wanted to mention to everyone that I found earlier we put in a resource, and I think it's Special Needs Association but it's a group that gives out information about special needs trust and special needs attorneys. And that's where I found Caleb. And they also have a YouTube channel as well that has great information and goes in depth into each one of these sections that he covered today. So make sure not only will it be on our YouTube channel, but you can find other resources on his as well. And because he's going to share the slide deck, I will post that on the NAMI Yavapai website. So you can either watch the whole video again or fast forward and or look at the slide deck. So thank you everybody for attending. I hope you enjoyed it. For future events, please go to namiyavapai.org. And to find mental health resources, go to mentalhealthresources.org. Thank you for viewing. Bye-bye.